Good morning.
Good morning. Can you hear me?
Yes, we can.
All right, very good. Do we have everyone that we need to have to get started?
We do, Your Honor.
All right, great. Just pull this up here, make sure I've got my documents. Looks like I do. All right. Let's go ahead and call this proceeding to order, and we're on the record. This is the Fort Myers Beach Special Magistrate hearing scheduled for Friday, May 16, 2025. We're getting underway at about 9:15 a.m. And I apologize for any delay on my end. I know there were some issues there as well, but I guess ironically I was the last to get on the to get in the meeting. But we are all together and ready to get started. And my name, for those who don't know, is John Van Lanningham, and I am the special magistrate for code compliance for Fort Myers Beach, and I'll be conducting today's hearings. And we have a few matters on today's agenda. Before we get to the hearings that are scheduled, we have a couple of administrative items, starting with the approval of the minutes from the April 1, 2025 hearings, which I've been provided. Are there any objections to the approval of those minutes?
No, Your Honor.
All right, without objection, then we will approve the minutes of the special magistrate hearings from April 1, 2025. And with that, we can begin moving through the matters that have been placed on the agenda for today. And I see the first item here are the compliance cases. And we can go ahead and start with those if you'd like.
Your Honor, we have another section in our agenda a little bit further down regarding our compliance cases, so I apologize for the oversight. We listed it twice. So we could go straight into the violation cases, if that's your...
That's fine.
Okay. So the very first case on our agenda today, first of all, my name is Nancy Stuprich. I'm an attorney with the Vos Law Firm, and we have the honor of serving the town of Fort Myers Beach as its town attorney. The first item that we do have as a violation case is 1698 Estero Boulevard, commonly known as The Goods. This is Fort Myers Beach case number 2024-0727. The property owner is Nautical Marketing, LLC. The property address is 1698 Estero Boulevard. The status of the matter is compliance. Your Honor, we have put a number of documents into the record, and we would ask that you accept that. In the record, you will find documentation that notice was complied with for the hearing today. I also want to add that Ms. Lezak is present today and will provide testimony to you regarding, she is the registered agent for Nautical Marketing LLC. I also have a code enforcement officer, Wick, who will provide testimony to you today regarding the status of compliance.
All right. And let me see, who do I have here then on behalf of the respondent?
Yeah, good morning, Your Honor. Jackie Lezak for the record.
And just so I'm clear, you're disputing the allegations in the notice?
No, Your Honor. I think she's
We're
here.
compliant at this point, yeah, so.
I also
Oh,
would
you-
like to draw your attention, Your Honor, to the fact that the parties did get together and communicated, and we worked with Ms. Lezak, she worked with the town, and we were able to facilitate a compliance of the violation that had been cited. We do have a stipulation agreement in the packet as well to the violation itself. So really the matter that should be pending before you today is whether or not to impose, we're not asking for a fine because compliance has been attained, and we have done that, no fine in any cases where we're able to get to compliance, but we would request the $250 administrative fee because of the fact that we have had to come before you today and incurred additional costs on behalf of the town.
Right. So let me go ahead and I'll receive into evidence these exhibits that the town has provided. And Ms. Lezak, I understand you all have reached an agreement as to the violation and come into compliance, so that's good. I misunderstood that at the outset. Is there any objection to the costs? I think the town is statutorily authorized to impose some costs of prosecution. Is there any objection to that?
I mean, we would absolutely ask for relief from the cost if possible, just because of everything that has and is continuing to go on the island. The folks in the goods who were on that are struggling to keep their business open, feed their family. They're working, not only were we neighbors, we're still neighbors, we're friends. We were trying to help them provide a living for their families. So if there was a way to ask for relief from that, that would be appreciated. If there is not, then of course, we'll take care of that so that we can get the matter closed.
I mean, I think the town would have to waive them since there's a statutory right to impose or assess them. I mean, we could, I suppose, get into a hearing as to the actual amount, although, I mean, in my experience, the $250 would be a rather not, a kind of a nominal sum, but, if you'd like, we could explore that in greater detail. Again, unless the town wanted to waive them, and they're obviously asking for the cost, there's a right to recover them.
Your Honor, just for the purposes of transparency, fairness, and consistency, we have asked for the $250 administrative costs in all our cases, so we would not be in a position to waive those. Again, it's taken some time, but it was time well spent because we were able to reach compliance to not only process the code enforcement case, but also to prepare the stipulation and to appear today on this matter.
Well, Ms. Lezak, I appreciate and understand what you're saying. I'll go ahead and assess the costs then. We have imposed that same amount on everyone, and there is a right for the town to recover costs. I will say, I mean, to the extent it, puts it in a little bit of perspective, I do a lot of code enforcement in different jurisdictions, and $250 is, I know it's, I mean, I wouldn't want to pay it, so I understand why you don't want to pay it. But it's
That's fair enough.
it's
I
a
don't wanna ask for
relatively small
something
sum as these cases go. I mean, in other places I see them much higher. So for what that's worth, maybe that's small consolation, but it's a relatively small sum for costs in a code enforcement case. It is the amount we've been imposing across the board in these cases. However, and I would agree with Ms. Stubrick that Ms. Stubrick, that would, fairness and consistency would require that we stay to that amount. Was
That's
that the
fair.
only matter that remained in dispute?
Right? Yeah, that's all that we have outstanding. So thank you. It's fair enough. We certainly don't want to ask for anything that anyone else is not getting, so.
All right, I will go ahead and then there's somewhere in the packet, I still haven't arrived at it. There's a stipulated order, or there's a stipulation. I can just enter the order based on it.
There is a stipulation, Your Honor. We did not prepare a draft order for your review.
That's fine. I can put one together. You've got the terms and the stipulation. I'll approve the stipulation, and that will resolve
Your Honor,
the
the
matter.
only other thing I wanted to ask about is in that it does state, and we did have some discussion about if there was another offense, it would be a second offense, and we had some discussion on that. So if we could get some relief on that, as this being scratched, and I don't anticipate any further issues. Certainly we're working with the town, and they've been excellent to work with on this, but I would not want to put myself into the position where if something else unknown in the future happened, as does seem to happen on this island a lot. I would like to at least give ourselves a little bit of leeway there.
I would say this again, not having read what's actually in the stipulation, but my inclination, unless there's something that surprises me there, would be not to address that issue in the final order, since it's sort of anticipatory. I mean, there may never be another offense, but if there is, and hopefully there won't be, the question about whether it's a repeat offense or not, I mean, we would take up at that time. I mean, it might be a completely different offense. It might, there's no point in trying to anticipate that hypothetically, and it hasn't happened yet. So why don't we leave that issue for another day, which may never come,
Perfect.
if that makes sense.
That makes perfect sense. Thank you.
All right.
Okay. All right. Thank you, Your Honor. Have a good day.
Thank you. Thanks for coming in. You're free to go.
So, Your Honor, if I may, the next item on your agenda is 1035 Estera Boulevard, KLC Surf. This is the Laola matter. As you are aware, well, let me go ahead and read the rest of it. It is Fort Myers Beach case 2024-0915. The property owner is KLC Surf LLC, operating with its tenant Laola. The property address is 1035 Estera Boulevard. The current status is non-compliant. However, there is an appeal pending in the circuit court. We are not asking for any action to be taken by you today. However, we did want to provide a status update to you. And I believe Ms. Toubeau is here on behalf of the property owner and the tenant.
All right, very good.
Good morning, Your Honor. Amy
Good
Toubeau
morning.
with Retzel for the record. Good to see you again.
I see you.
So we have some updates, as Nancy mentioned. This is, of course, in a circuit court appeal, but despite that, clearly the property owner and the tenant are both seeking to find a way to move forward collaboratively with the town. So they are working on getting plans for permitting. As they mentioned last time, we do have some renderings, and I can present those here in a moment. They did obtain their renderings. They're working on obtaining their engineered site plans and are in the process of getting their structural drawings done for permitting as well. We have submitted a request for a pre-application meeting for our development order application, which would be the first step in getting the rebuild approved. That is the town of Fort Myers Beach's site plan approval. So we are working to get that pre-application meeting on the calendar so that we can make sure that our DO plans are up to snuff. And so that's essentially where we are. And once we go through DO and we can get that, then we'll be able to submit for actual building permits. And who knows how long it'll take to actually build the site, but certainly once we break ground, we will be diligently underway trying to get Laola back up and running there at 1035 Estero.
Right, well, that's pretty good. And what stage is the circuit court case at? Have briefs, any briefs been filed, or is it still ramping up?
Yes, so our initial brief was filed 3.5 weeks ago or so. I believe the town's brief is due next Friday, but I will defer to Nancy on the deadlines. And then, of course, after that, we have 15 days to file our reply brief, which we will do. We'll work with the town to decide whether we want to request oral arguments or not, and then from there, hopefully, we will be seeing a decision rendered. Thankfully, the judge that is on this particular case is quite expedient, so we are hopeful to get this resolved as soon as possible.
All right, well, good. And just for clarification, I was looking over the agenda last night, and I recall this case was on appeal. What I didn't recall, and I don't really think it's an issue for today, since the town isn't asking for me to make any decision or ruling at present. But there's no stay in place. Am I right? I don't think that I entered one. Has the circuit court appellate division entered any kind of stay pending review?
Not at this time. That is certainly something we've discussed with the town, but nothing has been filed and no order has been rendered. Your Honor, certainly, it's my understanding that a stay would be ultimately decided by you. So, you know, if that were to be filed, we would be filing it with you and coming back for a hearing likely.
I mean, I guess, again, at the moment, it's not really an issue since the town isn't asking me to make some enforcement type of ruling. I mean, if it ever came to that point, I think, I haven't, looked at this in detail recently, but I guess absent a stay, the town could move forward with enforcement of the final order, even pending the review. Obviously, if the circuit court reversed, and some things might get undone, I won't speak for the town. I wouldn't guess as a practical matter, you'd commence, say, foreclosure action while you had a pending appeal on the final order. But I guess I just wanted to be clear. I didn't recall a stay, or recall seeing one. So again, it's not really an issue this morning since we're not taking up any kind of enforcement or other, immediate ruling. But I just wanted to be clear on that.
Yes, certainly.
Hopefully that'll never become an issue.
Hope
But
that's right.
if it does, we'll take it up, but
Certainly.
and it'll be fine. So there's nothing, I guess, for me to rule. I'm happy to hear further details if you want to get into it. I
Yes,
don't
Your
probably
Honor,
need to.
I thought, Ms. Chabot, were you gonna show photos, or do you want
Yeah,
to do that?
That's fine. I mean, I'm happy to,
And then I just have a couple things I'd like to add.
Thank you. So, I don't have the clicker, but I have 3 renderings that I just wanted to present today. So the first one is a rendering from the perspective of folks in Times Square. So this would be to the west of the site, closer to the beach. And as you can see, this is a really, really nice building that they've proposed. This is a perspective from San Carlos. And again, really nice. Those are, some of the restrooms. They've kept kind of a quasi tiki hut feel, but clearly we're looking at something that's a conventional structure, would be built, of course, in accordance with all state, federal, and local requirements, including Florida Building Code, FEMA requirements, all of that. And again, this is another perspective from San Carlos. So actually that mural on the old elevator shaft is there existing. So that's already there. The rest of that would be, of course, new structure. And we certainly think that this looks really nice. We think the architects have done a really nice job, and we're really looking forward to getting this project up and running.
Yeah, it does look nice.
Thank you.
I've never been, but maybe someday when this is all over, I'll get down there and I'll be able to see the beach there. It looks nice.
It's a really lovely spot. I think you'd really love it.
Well, great. Well, I'm glad to see those renderings, and I'm certainly hopeful, as I'm sure everyone is, that will move forward, apace, and that will be built, and that will be a nice, not only for the business owner, but for the town and the tourists and everyone else. So that would be a good result.
So, Your Honor, I wanted to add a few things. Yes, we will all be welcoming a new restaurant to our community. However, the enthusiasm towards the redevelopment of this site is not universal at this time, and I do want to explain to you why. So just to be clear, the violation that is the subject of your order that is on appeal, it's not for the failure to get a building permit or the failure to redevelop its restaurant. The violation is there because DOAH is operating in a non-compliant structure that is in violation of the town's flood regulations. They had the opportunity to move the non-compliant structure and continue on with their building and their redevelopment project, or to make it compliant, but they've chosen not to do any. You may recall at your January 7th public hearing that we had, the town asked you to impose a reasonable period of time for compliance. We left it open because we recognized the hardship that terminating a business would cause to DOAH. And they asked to be able to stay open until Memorial Day weekend. And you rightfully came into a compromise and gave them a compliance date of March the 1st. And to date, they have continued to be in violation, although they still, they did evidence, they provided evidence, they discussed their ability to exit the property very, very quickly in the event of a storm. So their continued presence creates 2 risks for the town and its residents that we're trying to figure out a solution to and how to best manage those. The first risk is the fact that hurricane season will begin on June the 1st. And our concern is the actual location. As you saw in the sketch, It is located at the foot of the Matanzas Bridge, which is one of the two only entries onto the island. The Matanzas Bridge basically intersects with Estero Boulevard, which unfortunately last night we had a dump truck that overturned with rebar that caused significant delays for people on the island as well as people coming to the island. And the concern that the town has is not only for the, and it is an inconvenience, the traffic. However, in the event there was some kind of medical emergency in the town, we're concerned that we would not be able to have rescue vehicles come. So if we have a storm, now that hurricane season has started, and LaOla continues to keep their non-compliant structures there, the town has a risk. Blockage of traffic as well as the inability to perhaps get needed resources in a very timely manner on the island. Second, I don't know if Your Honor is aware, however, FEMA has sent us a letter, and there is a copy of it on page 59 of your 139-page packet. We received the letter on April the 28th. We were very, very joyful. FEMA told us that the town is going to be taken off of probation. And FEMA recognized the hard work that the town staff has done in providing the information that they were looking for. However, getting off probation doesn't automatically provide the opportunity to participate in the NFIP, the National Insurance Program. And FEMA was very direct in their letter when they told us what the process would be. We would be taken off of probation on November the 18th. However, that removal from probation was conditioned on whether or not the town could document that the non-compliant structures have all been removed. FEMA will be coming to the town for a community assessment visit sometime before August the 31st of this year. We do not know when they're coming, and we are working feverishly trying to get the last couple non-compliant structures removed. However, should LaOla continue to not come into compliance, they are basically putting the town at risk once again of going into a probationary status with FEMA because of the fact that there is continued non-compliance. So I just wanted to put that on the record. I have spoken with Ms. Toubeau, and FEMA again has demonstrated that it can move those non-compliant structures, and they could continue on with their efforts to redevelop with those structures not present. As far as the appeal, yes, our answer brief is due next week, and then Ms. Toubeau has the 15 days to file a reply brief, and the town will then strongly consider asking for expedited review. The fact that Ms. Toubeau has said that she doesn't know how long the rebuild is going to take, that causes me even a little bit more concerned. However, the timing of the rebuild is not the solution to compliance for the violation. It's the removal of the non-compliant structures.
Thank you. And just to clarify, when I said I wasn't sure what the time frame for the rebuild would be, I was talking about the actual construction work. Clearly, once they break ground, there will be nothing that is there now will remain at that point. I just don't know exactly what the time frame is from breaking ground, getting their NOC to closing out your permit. Timelines are kind of all over the place right now, but what I can say is everything leading up to being able to break ground is being expedited. We are working very, very quickly. Certainly we understand the town's concerns. Without getting too deeply into it, we clearly disagree that there is a violation, and I would also make an argument that even if this was a violation, which it's not in my legal opinion, that the town has done everything that it can do to, you know, to adjudicate this case. So it would certainly be outside of FEMA's rules regarding probation to put the town back on probation if FEMA's only issue at that point was LOLA. So with that, Your Honor, thank you very much. If you have any questions for me, please let me know.
All right, well, thank you. Again, I guess, you know, because I'm not being asked today to take some kind of enforcement action to some extent. This is, you know, maybe forward-looking, and one of the reasons I brought up the issue of the stay. And I understand I think, the situation as it stands. I mean, there are risks from the town's perspective, and I guess there are risks from Laola's perspective, and that, you know, if the circuit court, for example, affirms the final order, then, you know, we have a situation where fines are accruing, and, you know, without a stay, I suppose the town could at least begin commencing some kind of enforcement action if it saw fit to do that. Obviously, there would be some decision points there, you know, potentially on a stay. My point is that, you know, the underlying violation that was found in the final order that's under review, subsists, and yeah, at least unless and until it, you know, that finding gets reversed. And at some point, if it's affirmed, there would, you know, again, be some additional decision points, but fines would be assessed, you know, based on the final order. Again, I don't want to get too far ahead of where we are. Obviously, there are various contingencies right now, including what might happen on appeal. But I mean, I guess what I'm saying, bottom line, is I understand that there are a few moving parts here, and there are various, you know, directions or turns this could take, you know, going forward. In the optimistic view, and, you know, my hope, and I'm sure the town's hope, surely the property owner's hope, is that the new building, the new structure will, you know, be developed and constructed, you know, in reasonably short order. Obviously, these things take time, and that will be an asset for, you know, for the community and obviously for the owners. Um, I'm not, you know, I don't know what the nature of objections to the development might be, but oftentimes, you know, people don't like it when you start building things, I guess, near the coast. I don't know what's going on there, but it looks nice in the pictures, and hopefully that'll get done. But you know, again, I don't want to get too far ahead of where we are today, other than to note that I understand that there are yet some decisions potentially to be made, and that might involve things like, you know, determining fees and that kind of thing. But we're not there today. Obviously, the Laola could, you know, if they remove the trailer, could, you know, minimize the risk of ongoing fines. Um, but that's, you know, I'm not being asked to take any enforcement step here, and so we'll deal with that if and when it comes. I'm not sure there's nothing really else for me to do at the moment, right? I mean, nothing other than to hear and, you know, be reminded of what's going on. It's kind of a status.
That is
But,
correct, Your Honor. We just wanted to keep you involved, and again, the town is, there will be some other cases coming to you with the last couple of non-compliant structures that we have that we're aware of. This is the last non-compliant structure in Town Square, which again, its proximity to the bridge and to the ability to actually circulate on the island is really a big risk for us in the event that the restaurant was displaced, you know, that the trailer ended up in the middle of Estero Boulevard.
Understood. All right, very good. Ms. Tebow, anything else?
I'm all finished. Thank you so much, Your Honor. Appreciate your time
All
today.
right. Thanks for coming in. I appreciate the update, and as I've said before, you know, good luck. I hope it, you know, I hope it goes forward. It looks nice. You know, it looks like it'll be a nice place if and when it gets completed.
Yes, thank you so much. Thank you.
Thank you.
Your Honor, the next case is a compliance case. And I am pleased to let you know, this is, first of all, let me put on the record the item that we're discussing. It's 131, 133 Estero Boulevard, previously known as the Island Shores Club. This is Fort Myers Beach case number 2025-0056. The property owner is Kaminsky at 131 Estero LLC. The property address is 131, 133 Estero Boulevard. The violation was property maintenance. I do have our code officer here who could speak to the compliance. In your packet, you will see that the demolition has occurred. The property is very clean. And we have received in advance a $250 administrative fee. The attorney for the property owner is present, and I'm sorry, it's usually Mr. Davies, but this is his associate, and I forgot your name. Samantha Encolada, and I'll let her comment.
Let me get your last name if I could. I got the first name.
That's okay. Samantha Encolada. Encalada.
DA. All right. And this is the case we had last time where there was a stipulation with, I don't know, one or two little wrinkles that had to be ironed out, but right, there were a couple of cases. The unsafe building.
Yes, that is correct, Your Honor. And per your order, there was a compliance date which we had timely met. There is actually in the file an affidavit of compliance on when that inspection took place. The date of compliance was April 30th, so well before the deadline that you provided in your order of May 9th. Also, Ms. Stuparich did mention that we did pay the fee in advance for the $250. So at this point, and based on our timely compliance, we are agreeing with Ms. Stuparich's representations, and we'd be asking that we have an order of compliance and close out the cases.
Right, very good. And have you all included a proposed order in the packet?
No, Your Honor. We will going forward.
If you want to just grant a form and submit that to me, I can go ahead and get it signed. I'm happy to do that. I'm always happy to hear that a case is in compliance. Everyone's in agreement.
Yes, we're trying to make it easy on you, Your Honor.
Okay, very good.
You know, and for the
Thanks a
record,
lot, Ms. Encolada. Anything else?
well, just for the record, we do appreciate them and you as well moving us to resolving this matter. You mentioned that there were some issues that we were talking about after your hearing. However, we did work it out, and I think everyone is in a place where they would need to be. The last item that is on your agenda is the building official appeal, and I think we need a formal order of dismissal. That appeal, again, it's the same address. It's 131, 133 Estero Boulevard. It was for an unsafe building, the property owner and their attorney is here. Just an order of dismissal because the unsafe building is gone.
All right. Again, happy to do that. And if you all want to just confer and send me an agreed upon form, I'll go ahead and get that signed. That's great. We'll get those two cases closed out.
We don't have any further cases, Your Honor. We do have the clerks that are here doing their job, and I understand we have a couple of still non-compliant structures coming to you on June the 3rd. Is that correct?
Oh.
And nothing further.
That was all of our cases? Okay.
That was it.
Well, that's great. I thought we had one, I guess that was the first one that it was resolved. So nothing really contentious today. So that makes for an easy hearing day.
Yes.
Excellent. So there are only a few more cases that are likely to come up that involve the non-compliant structures related to the FEMA issues?
Yes, and staff is working very, very diligently because of the fact that the community assessment visit is scheduled for August the 31st. We also had quite a number of cases where construction occurred without building permits. The town moved forward and sent letters, and we have achieved a very high percentage of compliance with after-the-fact permits. So those cases most likely will not be coming to you. However, there still are a few that we're gonna be pushing forward on.
Pretty good. I'm glad to hear that. Although I guess when everything's finally resolved, I may have put myself out of business here for Fort Myers Beach, but anyway, I'm glad that we're getting things moving and resolved.
Thank you.
That's
Yes.
good. All right. If there's nothing else then to take up on today's agenda, we're adjourned, and I will see you on June 3rd.
Thank you.
Thank you, Your Honor.
All right. We're